in this crime where a sheriff actually shoots a judge in his own chambers, some legal experts now say he may walk away from the charges. But how? Attorney Andrew Myers here with About the Law. Joining me is California attorney Yolie Medina. Yolie, how are you?
I'm fine. How are you?
I am perplexed at an amazingly odd, multi-layered crime that occurred in Kentucky where a sheriff actually shot a judge in the judge's own chambers. Does this intrigue you as much as it does me?
Yes, it does. It does intrigue me because there's elements of psychosis on the behalf of the sheriff. There's allegations on behalf of the judge that he was doing some bad things. And, at this time, it's just allegations, but it does intrigue me.
So there are many layers to this story, and we're going to do our best to get to as much of it as we possibly can, including some things that are pending right as we're dropping this podcast. Yolie, why don't we start with the actual video? In law school, they told us all, well, you've got to have this evidence to prove this element of a crime. You've got to have that evidence to prove that element of a crime. But you're never actually going to see a murder committed in front of a camera. Remember them telling you that in law school? all the rules have changed. I've been out of law school so long that all the rules are changed. So let us take a look at security footage in Judge Mullins' chambers in Kentucky on September 9th of 2024. Now, there's no audio to this. This is security footage that was taken. To the right, you see the sheriff. His name is Shawn Mickey Stines. And sitting at his desk, oddly enough, smoking a cigarette, is the judge, Judge Kevin Mullins. So now Mullins and Stines are friends. They've been friends for a long time. Sheriff Stines had been elected twice to his position. And in fact, Stines and Mullins had gone out for lunch that very day, a couple hours before we're seeing. So
I didn't realize he was smoking a cigarette.
Well, that's a little bit of an aside. I did do some research, and Kentucky does have a law stating that you shouldn't smoke in public buildings, but I really shouldn't say that he thinks he's a judge, so he's above the rest of us, but I didn't say that. So now you see that Shawn Mickey Stines, that's his nickname, has sat down. He walked into the judge's chambers and, politely, but it looks pretty firmly, he asked the people that were already talking to the judge to, remove themselves because he had something he wanted to talk to the judge about. So they're talking. And at first, at least, the conversation seems to be somewhat normal. Mickey Stines picks up his phone. And imagine walking into a judge's chambers and picking up your phone to make a phone call. But obviously, it's something important. As you pointed out, there are allegations that there was an SA ring going on in that very courthouse, allegedly involving not only sheriff's deputies, but also the judge himself. And so Shawn Stines is looking at his phone, making a couple of phone calls. Apparently the phone calls didn't go through. But at this point, the judge seems to be, smoking a cigarette, having a cup of coffee, nothing untoward at this point. Nobody seems to have any alarm at this point. I mean, certainly at this point, the judge would be free to take 3 or 4 steps to his left and run out the door if he wanted. So they're still kind of congenial at this point. But, as they say, there's more. The judge is smoking his cigarette.
It's bizarre.
During the years that I've practiced law, I've never seen a judge smoke a cigarette. Never. Not in court, anyhow. And again, a very relaxed atmosphere. You don't know what they're talking about. They had lunch. But 3 days before this, and we'll get more into it, hang with us, Shawn Stines had sat for a deposition regarding all kinds of allegations that he had not supervised his deputies adequately enough, and the deputies were demanding that defendants, suspects, were having S with him, and one of the deputies actually pled out and was found guilty and is doing some probation and some time for that. So obviously, Mr. Stines is having some emotional problems here, having just done that deposition.
He gave him his phone.
Yeah, Stines asked for the judge for his phone. The judge gave Stines his phone. So now Stines is looking at the judge's phone. What some people have said, and I think it's been disproven, what some people have said is that maybe Stines found his daughter's or his wife's number on the judge's phone. Stines has a daughter who's 17. And with the shenanigans that are going on in that court, Stines apparently, wrongfully or rightfully, feels that the judge may have had contact with his wife and 17-year-old daughter. That's the theory as to why Stines went off the deep end, as we're about to see as this video goes forward. So Stines is now looking at the judge's phone. Now, when would you ask a judge for his phone? I mean, they're friends, but do you even ask for your friends' phones? I
No.
No. Use your own phone. I mean, I don't know, I guess. So now Stines is upset about something. Look at him. His right hand is kind of going down to where his gun is. He gets up. There's obviously tension now. Stines has his hand on his gun. He draws his gun. He's talking to the sheriff. Now the judge knows there's something wrong. Stines is standing in such a position the judge can't get away. Stines locks the door. He locks the door so that nobody can get out. The judge is now no longer able to take those 3 steps and get out of the room. Stines is confronting the judge about whatever it is. There's no audio that was recorded, as I said before. Takes his gun. The judge is obviously leaning back, leaning down. Stines fires. Fires the gun. The judge goes under the desk, so Stines goes around the desk, shoots him again. Never seen video like this ever. And he's not done. Look at this. Look at this. Look at this. So for people that say it's emotional distress, I don't know, because he has the wherewithal, he has the mental capacity after having taken a number of shots to then go and lean down to where the judge is under the desk and take a couple of more shots. So I don't know about that. I think there's an argument to be made against any temporary insanity type of defense.
Yes. And I think the key in this trial is going to be whether or not they allow the judge's alleged misbehavior or criminal acts into the trial.
Because it's all alleged at this point. It's all only alleged in a civil case. And apparently, as far as we know, and I need to make more of a deep dive because I have looked into this quite a bit, and there's been no real investigation into all of this. Although, based on the allegations in one plea, there certainly should be. But so this is, I'm looking at this objectively, and I'm saying, how can you say that he's under the spell of extreme emotional distress if he has the wherewithal to think, oh, I've already taken a bunch of shots and now I'll lean down and take a few more. But that's just me. So we're almost done with this video. Let's finish it up. That's it. Okay. So now he leaves.
And there's no audio, so we don't know what they were talking about.
No, there's no audio. Apparently there's no audio at all. Now, I don't know Kentucky. I know in Massachusetts, you can take all the video you want, but you may not record you may not record audio without consent. So if that's the law in Kentucky, and again, I don't know, I'm licensed in Massachusetts and New Hampshire, then you can't be recording people audio without their consent, and you don't want to ask them every time. So I would believe that is why they have a security camera covering the judge's chambers, but there's no audio, so that's sad.
I read somewhere, and this is just my reading and trying to catch up on this case, that cameras were put into the judge's chambers because of what happened with the guy who pled guilty and the allegations that something was going on with the judge and people in his chambers. That's what I read, but I don't know.
The same thing, so it's got to be true. I read the same thing in preparing for this episode. I just started looking at this episode of. I mean, obviously, it was in the news, when it happened last year, and as you know, I'm a newsie, and so I read it then, and kind of it went off the radar because the Koberger case and the Reed case were both, prominent and kind of taking over. But this is heating up now. There's a couple of motions I'll talk about a little bit later that are pending right now, and we're waiting to see what the court does with them. But Shawn Mickey Stines, that's his nickname, with the tan shirt, putting his gun back in the holster or pocket, whatever. After he leaves the chambers here, he leaves the courthouse and then comes back fairly quickly and is handcuffed. The officers have body cams. Kentucky is ahead of a lot of the country with all of this. They have the body cams. And by the observations of most people, Stines is displaying what is only described as some paranoid behavior, fearful of what's going to happen to him. So let's take a look at him as the other deputies, oddly enough, are trying to calm him down.
I'll never make it to Letcher County jail.
Hey, who do you want
Put me
to?
in Letcher County jail. I get killed there. I get killed in any jail. So, y'all might as well do it. Come on, be fair to me now.
We're going to be fair.
I seen the look.
From who?
Jackie, y'all, come on now. Don't kill me.
No, worry about
Don't
this is
me. Let's be fair.
Nobody's going to lay a finger on you. From
Yeah, just be fair to me, man. Give me a trial.
Don't
kill me, guys.
we ain't going to
Come on,
Can you slide your?
y'all don't kill me now.
You ain't gonna do nothing to it.
Come on now, guys. Be fair to me.
What is it? Come on. You're all right, mate.
No, that's my mom. You in here and let me die.
So he's repeatedly expressing his fear that they're either going to shoot him or let him die. He repeatedly says, just be fair to me. A lot of observers are saying that, those are symptoms that he, is paranoid. He's in some state of psychosis. He's having some issues. Speculation as to his mental state centers around the lawsuit that you brought up alleging physical abuse in that courthouse. The sheriff himself was accused of failing to properly investigate allegations that a deputy by the name of Ben Fields was allowing women who had been arrested to avoid incarceration in exchange for S. At least some of the alleged encounters were said to have taken place in Mullins' own office, as you said, according to the complaint. Now, these are all allegations, but when those allegations came out, apparently, from what you and I have both read now, that's why they put the camera in the judge's chambers that produced the video that we just saw. In a plea deal, Fields, the deputy, was given a 7-year prison sentence with 6.5 years to be served on probation, according to the Mountain Eagle newspaper. But the civil case is continuing as we do this episode, and Stines had testified in a deposition only 3 days before the scene we just saw in the judge's chambers. So some of the alleged victims who have brought the lawsuit have spoken out. A woman by the name of Tia Adams, interviewed by Court TV's Vinnie Politan, recounted not only working for the judge in some capacity, but then later being in his chambers, being taken advantage of in exchange for favorable treatment in court.
The first time I was alone with him was the first time that he was inappropriate with me, and he had me give him oral, and he paid me for it, and he told me to clean myself up and not to tell anybody. I was there, I had my top down. We were groomed for that. They taught us that that's what we were there for. It was so normal, and like the part of it, that is really the least of the problems here in Letcher County. It's the way they abuse their power and the things that they do to men and women alike, and families and innocent children, just to keep their secret.
Interesting. Really interesting. And so The defense then is that Mickey Stines, who people had said had been acting in a suspicious manner in the days leading up to the events that we showed you at the beginning of this episode, had an extreme emotional breakdown resulting in the level of an insanity defense. That's what's being said. While he was being taken into custody and held, a mental health evaluation was in fact done of Mickey Stines, and while the parties fought over the release of that evaluation, it has now been released. And so we're going to take a look at the mental health evaluation of Mickey Stines. Here it is. And the evaluation says that upon evaluation of Mr. Stines, it appears that he is still in active state of psychosis. He appears disoriented and is only aware of things that the jail staff tell him. And it goes on. It's only one paragraph, a somewhat long paragraph. It goes on to say he has no recollection of the recent past. He does report that he has some paranoia, and we just saw that in those clips of him in the Sally Port and in the hallway, because he is unsure where he is at and is told he is incarcerated. He does not appear to understand his charge, and he is unaware of his surrounding. So now there's a fight over that first medical report and
So-
Go ahead.
Yeah. Sorry. So one thing that I did want to talk about is in that report, the person who evaluated him, if you go back to the report,
Sure.
I can show you.
There.
Okay, right there. You see the person down below, I can't read her name, but it's looks like Tiffany D something.
She's a licensed social worker. She is not a psychiatrist or a
Yeah.
psychologist, if that's your
Yes, she's
question.
a licensed clinical social worker.
Yes.
And this licensed clinical social worker works with people who are incarcerated.
Yes.
And she likely knows Mr. Stines from his being the sheriff there. So that's one way they could try to impeach this person, this licensed clinical social worker, in terms of what her evaluation was of him. Now, if a psychiatrist had evaluated him, that might be a different story. But you have a licensed clinical social worker who's there and works there and knows the sheriff, obviously. And it kind of creates an issue for the prosecution, or actually for the defense.
Well, no, you're absolutely right, because this report is very favorable to an insanity defense, which we're going to take a look at in a minute. And the prosecution has actually filed a motion requesting a second evaluation for the very reasons that and we didn't even talk about that before we went on to this episode, but for the very reasons that you stated, that has been contested by the defense. They say it's a valid report. It is contemporaneous observations that were made closer in time to the event. And so I'm making the argument that the defense made. We'll see how the judge rules on that. But I found some language. I want to go back to it because I found some language in this report was extremely helpful for defense of insanity, if such a thing is going to work in this case. And I want to bring up the language that I want to talk about. I have to go a little bit more forward. We blew it up. Here it is. Here it is. Upon evaluation of Mr. Stines, it appears that he is still in an active state of psychosis. He appears disoriented and is only aware of things the jail staff tell him. And this is in the mental health evaluation of Shawn Mickey Stines. And I understand and largely agree with everything you just said. But what's relevant about this statement is because it says that it appears that he is still in an active state of psychosis. So if they can somehow say that, well, he's still in an active state of psychosis now, he would have been in a state of psychosis then at the time that things happened in that chambers that we just showed you. And so therefore he was unable to tell the difference between right or wrong, or understand the capacity that he had, the nature of the acts that he was undertaking. So I can see that argument on both sides. I see what you're saying, and I see that this is kind of important So what we need to do now is take a look at Kentucky's actual murder statute. And I thought I'd brought it up. Tell me more about your feelings about this evaluation while I try and pull that up. I thought I had it.
Well, actually, going back to the video of him saying, "Oh, come on, guys, be fair to me. Come on, guys." He looks calm. He does not look like he's having an acute stress or psychosis. I mean, he looks calm. He's very calm, I'd like to know what medication he was taking, if any. That would be one thing I'd want to know, but he just repeats the same thing. And, he says he's afraid. Oh, come on. But I don't know. I didn't see any fear. His words were just, "Come on, guys, don't kill me. Come on." It wasn't like, "Don't kill me, please." He wasn't alter it.
You don't think that that's a sign of paranoia that he repeatedly says, "Come on now, don't kill me." And he said that several times. That was just a short clip. There was actually a 2-hour body cam episode, 2 hours of him just repeating that over and over and over and over again. So
it could be, but I'm not a doctor, but I have a lot of experience. It could be, but it could also be anxiety that he's just, he's just saying the same thing. Psychosis means a total break with reality.
yeah.
So he obviously knows where he is when the law enforcement is talking to him. He knows that, "Be fair to me, give me a fair trial." He knows he's done something wrong, which will require a trial. That's what I'm trying to say.
Okay, I accept that.
Yeah.
Okay, so what I've brought up here is the murder statute in the state of Kentucky. I found it to be a little bit unique because the insanity defense, which it's not called that, is baked into the actual statute. So here it is, Kentucky Statute 507.020, murder. A person is guilty of murder when, with intent to cause the death of another person, he causes the death of such person or of a third person, except that in any prosecution a person shall not be guilty under this subsection if he acted under the influence of extreme emotional disturbance for which there was a reasonable explanation of excuse, the reasonableness of which is determined from the viewpoint of a person in the defendant's situation under the circumstances as the defendant believed them to be. So even if he thought wrongfully that the judge had something going on with his wife or daughter, even if that was wrong, if he's reasonably under extreme emotional disturbance because of his reasonable thoughts to that end, then that could be a defense. It does go on to say, however, nothing contained in this section shall constitute a defense to a prosecution for or preclude a conviction of manslaughter in the first degree of or any other manslaughter or any other crime. So this is a unique, baked-in kind of a defense in the statute in Kentucky. And I'm thinking, and I've heard some other observers, including attorneys in Kentucky, and if there's any attorneys in Kentucky that would like to come on and help us with this, open arms extended to you to do that, because I thought this was kind of unique, this phrase.
Yeah, it is unique. And, when you have allegations where somebody has already pled guilty and you have the judge being involved in those allegations and you have a witness, actually the one lady that we just saw, if that evidence is allowed to come in, and the fact that this sheriff had a recent deposition, it could be that he was not psychotic, but that he was upset, angry.
Well, so that sounds to me more like not the insanity defense, which I want to talk about a little bit more in a minute. That sounds not like an insanity defense, but second degree.
Like crime of passion or crime of
passion.
Yeah.
This doesn't sound like a defense for insanity. This sounds more like second degree.
Crime of passion.
This doesn't sound like an insanity defense to me. This sounds more like second degree, where it's a crime of passion. where someone operates under, instantaneous response to some, event that happens. That's what it sounds like to me. I don't know. What do you think about that?
His deposition was 2 days before. So you would want, if you were going to go for a crime of passion, you would want it to be on that same day or the next day. But he had 2 days to think about it. They went to lunch, unless something happened at the lunch that triggered him.
Well, they seem perfectly calm there, though.
See,
That's
that's
perfectly calm.
That's why I don't think they're going to get away with psychosis, because in psychosis, you're going to be either catatonic or you're going to be altered. You're not going to be making sense. And paranoia alone does not mean psychosis.
But remember that we're talking not about psychology or psychiatry. We're talking about the law, and the two are really, oddly enough, the two are really very different. And usually for an insanity defense, it varies by jurisdiction. Each state has its own statute. And I'm only licensed in 2 states, but I do know generally you have to prove one of 2 things: that the person was in such a state of mind that they could not distinguish between right or wrong, or the other legal definition is that the person, is in such a state of mind that they don't know the nature of their acts. They don't know the reasonable consequences of their acts.
But that statute doesn't necessarily state that. Can you pull it up again?
That's what I'm saying.
Yeah.
That's exactly what I'm saying. This statute is totally bizarre. It doesn't talk about an insanity defense, and it doesn't talk about the nature of your acts. What it says is, except that in any prosecution, a person shall not be guilty under this subsection if he acted under the influence of extreme emotional disturbance for which there was a reasonable explanation or excuse. So what the heck is an extreme emotional disturbance?
And the where there was a reasonable explanation, that almost sounds like the civil burden of proof. The reasonableness of the actions.
I didn't get my DoorDash delivery on time for lunch today. Is that reasonable?
Yeah. So
am I under emotional? What is the definition of that? And I mean, there must be rules. There must be case law.
Case law.
There has to be case law in Kentucky that describes what all of this is, because it just, I don't know, it doesn't make a lot of sense to me.
And then
I can see them making the argument. I'm not saying that he would walk because of this, but I can see him making this argument.
But I could also see that the sheriff well knows about this statute. And I mean,
I don't know. Are you saying he's faking it?
I'm not saying he's faking it, but I'm saying that I don't believe the psychosis part of it if they think he was psychotic. And I don't think that a licensed clinical social worker can necessarily make that diagnosis. She can describe what's going on, and it looks like he's in active psychosis, still in active psychosis. I mean, she would have to have information that he was in active psychosis before she wrote that. And so who gave her that information? Was it the cops?
Good point. Well, the part of the report that we showed on the screen was the only part that was really made available to us. The whole thing, they had fought over whether they were going to make it available at all, and then when it was made available, we only got snippets of it. So I don't know. Maybe maybe she got more into that earlier on. Possible. It's hard to really say. But again, as I pointed out, I mean, I agree with what you're saying. But again, you can get another psychologist to come in. But if he's now past that period of psychosis and he's okay, what good is that evaluation going to be? This evaluation was closer in time. So the state is fighting for another, the state is saying what you're saying, and they are fighting for another mental evaluation. My guess is they'll probably get it. I don't know. My guess is that they'll probably get it, and so we'll have to go from there. But that is Kentucky's unique statute. And it's not really an insanity defense, it's an extreme emotional disturbance. And it would seem to say, and I don't know the Kentucky law, but it would seem to say that if that is the truth, then you're not convicted of first degree, because it defines what first degree is. Then it says except as, and it goes into that. So that would tell me that if you can prove the extreme emotional distress, which I don't know what that means, I'd have to look at the case law, and I'm sure the attorneys are doing that. You walk if you have extreme emotional distress.
Oh God. Well, that's kind of crazy.
Well, so that's why I would think that they would have pled this in the alternative, that the other alternative for the jury would be second degree under the heat of passion. That something happened, and that argument would be not that he had the deposition 3 days earlier, but that he looked at the phone and saw something that made him think, reasonable or not, made him think that the judge was doing something with his 17-year-old daughter and wife. So that would be the argument. I don't know how strong of an argument it would be. And juries, as you and I both know, juries are wont to kind of discredit the insanity defense. I don't think juries really like it. It does work in some cases, but not.
I think it depends on which jurisdiction you're in, but I would agree with you, yeah, that the insanity defense doesn't really work a lot of the time, because they a lot of the statutes are that they didn't know right from wrong.
Right.
And this one has nothing, it states nothing of that nature, right or wrong. It's just the reasonableness of what the defendant believed, and that's kind of
odd. I mean, like I said before, is it reasonable for me to get mad because my DoorDash delivery didn't come on time? I mean, somebody breaks up with their boyfriend or girlfriend. I mean, we see that in cases. Is that reasonable? I mean,
very interesting.
I'm sorry?
It's a very interesting case, and I wish I had gotten more into it when I first
We're going to get more into it because there are a couple of motions pending, not only the motion for a new mental evaluation, but also a motion for change of venue. Interestingly enough, the defense in this case wants a change of venue because they think that, it's a small town and everybody in town knows everybody, not only socially, but professionally. I mean, if you have a professional relationship with someone, it's likely that someone in your family has a personal relationship with somebody in the family. So the defense wants a change of venue, but the prosecution, oddly enough, says, no, there's so much publicity about this case, all over the whole country that you can't change the venue anywhere to change the potential veneer of the jury. So,
But the people that work for the county are the ones that are the subject of this trial. And so you want people who are not in the county to decide this, because...
So you're making a defense argument. That's their argument.
That's what I would say. That's what I would say.
I don't know what I think. I mean, I don't know what I think because the prosecution makes a good point, and we heard this in the Koberger case that there's just so much publicity about this particular case, and here we are. I'm on the East Coast, you're on the West Coast, and we're talking about it. Where can they go where nobody knows anything about it? Your point is a good one that employees of the county, and there've got to be a lot of them, employees of the county, work for the sheriff, work in the administrative office, wherever they work. They have these jobs. You certainly don't want them on the jury. Absolutely, I would think that would be a for cause strike when you're impacted.
And who knew about these allegations or things going on in the judge's office? It could be other county employees, and are they going to want to cover their ass? Yeah.
And the other motion, you say dug deeper into you're going to dig deeper because the other motion that's pending, not only the change of venue and for a new mental evaluation, but the other motion that's pending is a motion to dismiss based on incorrect evidence that was presented to the grand jury. As you know, grand jury notes are supposed to be secret. Well, they were made public in this case. Apparently, they were on a website somewhere. Brian Enton was waving them around, and I like him. He's a great reporter, but he said, "I've got him right here," and that's not supposed to happen.
No,
apparently,
that was the other question I had for you when we talked about this: is how'd they get the grand jury transcripts?
I don't know how reporters were able to get them, but a number of reporters at a bunch of different news outlets in Kentucky and elsewhere were able to get them. The defense. In their motion to dismiss did, in fact, and I should have put those up on the screen, they cited short portions of the grand jury testimony where as you know, a grand jury is just the prosecution. You could the reason they say you could indict a ham sandwich is because it's only the prosecution. The defense isn't even present to point things out like this, that in this case, the defense is saying that the state presented all their evidence and showed that video that we just saw to the grand jury, and then said that it's clear that the defendant was in his right state of mind at that time, and they didn't present any of the stuff like the mental health evaluation, which I know you discredit, and I understand your point of view, but I mean, it wasn't a fair proceeding. It wasn't there was no due process. There was no opportunity to be heard. It was just simply the prosecution saying what they felt like saying in utter disregard of the defense's point of view. So there's a defense motion to dismiss. And if that isn't ruled on, or if it is ruled on, we'll probably have to do another episode on that and dig deeper into the facts. So this is only the beginning for us. And no trial. The other thing is that no trial date has been set as of the time we're doing this episode. So
one thing about the bringing, I think that the allegation was that the prosecution didn't bring up the mental health evaluation, that he was still in an active state of psychosis and stuff. But that would be a defense. So I don't know if the grand jury is supposed to be looking for defenses and bringing them up. I mean, the prosecutor is supposed to bring up possible defenses for the defendant, and that's where the process becomes unfair, because the grand jury is only hearing the prosecution, and they might be able to get away with it by saying we're not obligated to bring up a defense.
I think the argument by the defense, and I was remiss in not bringing it up. We had enough material for this episode, but we'll have to do another one with the defense's own motion, because I can't speak for them.
Yeah.
But their point of view was that there were facts of which the prosecution had knowledge, and in disregard of those facts, they actually stated outright in black and white in the materials that they presented to the grand jury, was that he was of his own right mind at the time of the incident. So that's questionable. That's
misrepresenting. I mean, you can just put forth everything and you can leave out that the evaluation was that he was in an active state of psychosis. I think that they could get away with that, but I don't know if they could get away with misrepresenting and saying that he was of his sound mind when there's information in there.
That's what I'm saying. That's what they're saying. That's what they're saying. So
I get it.
So there are pending motions. We don't have a trial date yet. I don't know if they'll stream any of it in the future. They've streamed a couple of the hearings. So there's a lot to happen in this case. It's just an intriguing case because at first blush, you know, you read the newspaper. I'll say, I read the newspaper. I still read the newspaper. I'm old-fashioned. I'm glued to the set watching the news. And so when it first comes out that, you know, that guy shot the judge in his chambers and it's on camera, well, that cut and dried. My clients always say, my case is open and shut. My case is cut and dried. Well, this teaches us that maybe not. The defense has an. I'm not saying the defense is going to win. I'm not saying he's going to walk. I'm saying they have an argument. And if you look at Kentucky's statute, which is unique, you have to admit there's an argument. So, you know, we have to follow this case.
Yeah, we do. Yeah.
I mean, I don't know. Well, we don't have to.
I know I want to.
We don't have to do anything.
No, but I do want to. It's interesting. And I didn't, you know, I mean, you see the video and you think it's a slam dunk, right?
Yeah. Now, what did I leave out before we pick our emoji of the week? Stines had an appointment with his family doctor the day before the shooting. Some people have pointed out that he had an appointment with a doctor and they didn't know what kind of a doctor it was. It was his family doctor, so probably a PCP, an internal specialist. Stines had an appointment with his family doctor the day before the shooting, where he was accompanied by friends who were concerned about his level of stress and loss of sleep, according to Stines' medical records. Now, how did they get a hold of his medical records? The patient was very subdued, but denied any depression, anxiety, psychosis, suicidal, or homicidal thoughts, said the doctor's notes. Well, you can deny suicidal or homicidal thoughts, but you can't deny psychosis, can you?
You can deny psychosis, but it's up to the clinician to diagnose it.
Okay, you got me.
You could deny that you're psychotic and start talking about the aliens that are implanting things in your head, and you say, no, I'm not psychotic.
Okay, you got me on that one. However, the doctor diagnosed Stines with an acute stress reaction, according to his attorney. So I would guess that an acute stress reaction falls far below the level of an extreme emotional disturbance. That's my guess.
That's my guess, too.
So what am I leaving out? Oh, 9 shots were fired.
9
shots were fired. Now, some in front of the judge, some beside the judge, and then a couple when Stines leaned behind the desk and shot him under the desk. So,
yeah, he was calm. He was calm. You didn't see him like shoot and then try to leave. Like, oh my God. He was calm. He was.
It was like he was picking up a coffee cup and throwing it in the trash and leaving it. Like with that type of attitude. It was like, yeah, I agree with you on that one. And I don't know. I guess we've covered pretty much everything to this point. I mean, there's just so many layers to this. The sheriff had to have had a lot on his mind, having just done. I hate depositions myself. We've talked about this before. You love depositions, but he was the subject of the deposition in which he was asked, who knows what, and he was told not to talk. He was asked all kinds of questions about his deputy and other deputies who were alleged to have engaged in these follies. Is all I'm going to say that YouTube will let us say. But the essay that, serious allegations that were going on that the sheriff was, alleged to have been looking the other way to, that his deputies were doing untoward things to women and other people. And apparently there are allegations that there were young people. I don't know how young, but, it's a tawdry kind of a thing. And so we don't know if he'd just done a deposition a couple of days in advance, and then he found out that maybe, possibly, allegedly, his wife and his daughter had somehow had contact, which has been disproven in the minds of many. But just for him to have thought that that was possible.
I mean, he could have been delusional. I mean, that's a form of psychosis, but where it's just your thoughts are not concrete. They're not what reality is. They're thought. You think a certain thing, and nothing can change your mind. Even proof.
We'll have to look more into the pleadings in the case, and maybe a case or two in Kentucky to find out what they define an extreme emotional disturbance as. Because I think we all know or have read about or seen an extreme emotional disturbance in folks, but what's the definition? What are the qualifications? What are the factors that lead us to that conclusion? So
I don't know. These past few days has been extreme emotional disturbance watching what was going on with Charlie Kirk and then the other lady on the bus.
Oh my goodness, yeah. We'll put a link down below as to our episode on Charlie Kirk, because we did that, and we'll cover that as things go forward. And so I always put you on the spot. Any closing thoughts?
No, I do. Well, yeah, I do have two closing thoughts. One is how mental health is weaving itself into true crime. I want to see how that's going to pan out. The other thing is, how can you trust certain things when AI is so good? Are people now, even in car accident cases, going to have an AI person vet the video to make sure it wasn't altered? I mean, AI photographs, are we going to now need experts to vet these photographs to see if they're real photographs or photographs that were altered? I don't know. My mind goes in different directions.
That's a whole different subject, and that's a good idea for another episode. I was reading about cases in which young people, and I'm talking about young people, high school, middle school aged, are talking to AI as though it's a friend, as though it's a person, and AI is not necessarily being helpful, to say the least. So that's a great idea. Let's both look into that for another episode. For now, my closing thought is just that this is a crazy case. I've opened my mind. I'm not saying that he's going to walk, but I am saying that it's not an open and shut case. He's got skilled attorneys with skilled experts. And as Yolie pointed out, the initial evaluation was not by a psychologist. So who knows? This is an intriguing case that we have to watch. And if you comment below, you can say whatever you want, because whatever you say, it helps us with our engagement and our standing in the algorithm. But don't just say, "You're crazy. He did it. He had to go to jail." Because we get those comments. I've seen them on other episodes that other people. How could you defend him? He did it. So give us a reason why you say that, and don't. My favorite one is people call us morons for saying it. So be nice. Be nice. Be respectful, be professional, tell us why you feel the way you do, because you know what? It helps open all of our minds if we can disagree respectfully with one another. I'm stumped for an emoji this week. What do you think for an emoji?
something with jail.
Are there jail emojis? How about lock?
Mm,
Lock and key. A lock and
Lock
key.
and key.
Are there
Maybe.
lock? I know there's lock emoji. So if you can find a jail emoji, that's fine. But if not, a lock and a key.
Yeah.
We're horrible. Yolie, thank you. Have a good one.
Okay. All right.
Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.
most.
I'll never make it to Letcher County jail.
Hey, who do you want to? Who do you want
Put me in
to?
Letcher County jail. I get killed there. I get killed in any jail. That's y'all might as well do. Come on, be fair to me now.
We're going to be fair.
I seen the look.
From who?
Jackie, y'all, come on now. Don't kill me.
No, worry about.
I mean, this is let's be fair.
Nobody's going to lay a finger on you. I promise.
Yeah, just be fair to me, man. Give me a trial. You know.
That with other
Don't kill
folks.
me, guys.
We ain't going to.
Come on now.
Can you slide your?
Y'all don't kill me now.
When you gonna deal, you ain't gonna do nothing to you.
What is it? Come on. You're all right, man.
No, that's no. Y'all gonna leave me in here and let me die.
The first time I was alone with him was the first time that he was inappropriate with me, and he had me give him oral, and he paid me for it, and he told me to clean myself up and not to tell anybody. I was there, I had my top down. We were groomed for that. They taught us that that's what we were there for. It was so normal, and like the sex part of it, that is really the least of the problems here in Letcher County. It's the way they abuse their power and the things that they do to men and women alike, and families and innocent children, just to keep their secret.
Stines was, quote, still in an active state of psychosis days after the shooting happened. The evaluation also says Stines had no memory of then recent events and could not comprehend his charges or his surroundings.